Welcome everybody, and thank you for joining us for another webinar event in Conn Maciel Carey's 2016 OSHA webinar series. This is the third webinar in our program, and today we'll be talking about OSHA's Process Safety Management Standard and the EPA's RMP rule. A little update on the regulatory issues related to those two standards, both from a rulemaking standpoint and an enforcement standpoint, and also a series of controversial interpretation letters that sort of fit in between those two things. They look an awful lot like rulemaking, but really we're seeing them just in the context of enforcement. I'll introduce ourselves real quick. The faceless voices you're going to hear today. This is Eric Conn. I'm one of the founding partners and the chair of the OSHA practice group at Conn Maciel Carey. We are a law firm that's been around not quite 2 years yet, but we've been practicing law in the field of occupational safety and health and environmental law for a good deal longer than that. My practice focuses exclusively on occupational safety and health law. I work with my clients to help manage inspections, investigations, and enforcement actions involving OSHA, the United States Chemical Safety and Hazard Investigation Board, EPA, MSHA, and other state and local related agencies that regulate safety and health issues. I help my clients respond to and manage investigations of catastrophic industrial, construction, and manufacturing. Testing. Sounds like we've lost audio here. Hold on one second. Let me try and do something different. Computer audio. All right, can everybody hear me now? All right, well, please let me know if it drops out again, and we'll see if we can figure out why that happened, but it sounds like I'm back now. The computer was tired of hearing me talk about myself, so with that, I'm going to let Amanda introduce herself real quickly, and then we'll jump into the substance of the presentation.
Good afternoon. My name is Amanda Stranis-Walker, and like Eric, I practice exclusively in the occupational safety and health work practice area. Do cover some RMP when it overlaps with PSM. And my prior experience includes an appointment at the Department of Labor, where I worked on OSHA issues both in the front office of OSHA as well as the solicitor's office, and have been in private practice since 2009 in practice. I guess it's coming up on 5 years with Eric, and cover many of the same things that he mentioned before, pretty much everything from the compliance assistance up front to the enforcement and litigation that can result from inspections. Thanks.
All right, so what we're going to talk about today, this is just a sort of general get caught up on what's been going on with PSM and RMP, and that catch-up involves a heck of a lot. There's been a tremendous amount of activity in this space after years and years of sort of regulatory landscape that looked, unchanged. But following the tragic incident in West Texas, the fertilizer explosion incident, there has been a tremendous amount of activity, and our timing here looks fairly remarkable. We scheduled this event, at the end of last year, and we're holding this event just 2 days after EPA published in the Federal Register a proposed rule to amend the RMP regulation. So there's a lot going on. So we're going to be talking about President Obama's executive order that followed the West Texas incident, and all of the things that have flowed from that, including the efforts by EPA and OSHA to amend the PSM and RMP regulations, some new enforcement issues both by OSHA and EPA, and then also finally the controversial new PSM interpretation letters, what those interpretation letters mean, why we've suddenly seen a spike in regulation by interpretation, and what the status is of some legal challenges to those new interpretations. So let's start off by giving a little background about why we're seeing so much activity in the context of chemical safety regulations. The main reason we're seeing this is that there was an executive order issued by President Obama back in August in response to the West fertilizer explosion. And this was a big, huge, high-profile incident in the context of, a highly hazardous chemical that was not particularly heavily regulated, or a workplace that was not particularly well regulated. And so the president and the public cried out for a greater level of scrutiny over America's stationary chemical manufacturing locations, or facilities where there are large quantities of highly hazardous chemicals. The executive order 13650 was entitled the Chemical Facility Safety Chemical Facility Improvements or Regulatory Improvement Executive Order, and it established, the primary thing that it did was establish a working group, the Chemical Facility Safety and Security Working Group, that was comprised of the litany of regulatory agencies that had some role in managing the regulatory framework for highly hazardous chemicals. Primarily that was the Department of Labor, OSHA, the Environmental Protection Agency, but the working group also included Department of Homeland Security, Department of Justice, USDA, and the Department of Transportation, all who have some role in regulating chemical workplace safety. The working group got together and started to take actions to implement the executive order, and those actions took a series of different phases, from focusing on community planning and preparedness with emergency response groups, both public and coordination of public and private emergency response organizations, improving coordination of emergency response, developing and consolidating data management around where highly hazardous chemicals are being used, the types of workplaces, volumes, and the manner in which those chemicals are being handled throughout the country, integrating stakeholder feedback and trying to develop best practices. But the primary thing that this working group has been focused on has been modernizing regulations and policies. And I'll confess that when this working group was put together and announced its agenda, talking about modernizing regulations and policies, I focused really on the modernizing regulations piece of this. That meant we were going to see rulemaking by EPA, by OSHA, perhaps by DOT and others, in the manner in which highly hazardous chemicals are being regulated in this country. And I didn't pay as much attention to this idea of modernizing policies. And Amanda is going to talk at the end of the presentation today about how, in particular OSHA, but also EPA, have been making efforts to modernize policies without going through the rulemaking process. So, you saw on the agenda a discussion about these interpretations, and we put interpretations in quotes because we view these really as rulemaking changes, policy changes that have been made without going through the rulemaking process. So really our focus today is on those two aspects of what the working group is doing in response to President Obama's executive order, the efforts to update PSM and RMP regulations, and also some policy changes we've seen that are affecting the way American workplaces must handle highly hazardous chemicals. So we'll talk a little bit about some of the actions that the working group has taken, and then again focus on the rulemaking efforts. Shortly after the executive order was released, the United States Department of Labor, OSHA, issued a request for information. This was a precursor to a rulemaking effort. So back in December 2013, OSHA put out its RFI for ways to expand and amend the Process Safety Management Standard to address issues that OSHA had learned about its standard over the 20-plus years of implementing the PSM regulation. A few months later, in July 2014, EPA issued its own RFI for ways to expand and amend the Risk Management Program rule, which is EPA's corollary to OSHA's PSM standard. In June and July of 2015, a couple of years later, OSHA issued these interpretation letters covering the way OSHA will enforce recognized and generally accepted good engineering practices, different ways to calculate and determine PSM coverage based on concentrations of chemical mixtures that include Appendix A chemicals, and changes to what had been a well-established retail exemption to PSM coverage. And Amanda's going to talk about those at the end of the presentation. Following the RFIs, there was an opportunity for industry to respond, and industry did respond substantially to these requests for information about proposed changes to the PSM standard and the RMP rule. Following that, EPA jumped into the lead and initiated an SBAR or SBARFA Small Business Regulatory Review process. And that process ran from around September 2015 and just closed earlier this month with a report from the SBARFA panel about the interaction that small business had with EPA, talking about the specific proposed amendments that EPA had in mind for the RMP rule. And simultaneously, or within a few days of closing that SBARFA process, the EPA published just Monday of this week. Our timing couldn't have been better to have this webinar. The Monday of this week, EPA published a proposed rule in the Federal Register. And this proposed rule is different than a lot that we've seen before. It does include specific proposals that EPA would like to make to the proposed rule, but it also invites discussion from industry about alternatives to the proposals that EPA is making. So there's an opportunity here to comment on specifically what EPA has in mind, but also to either propose or to comment on alternatives to what EPA is proposing. The OSHA had sort of set its rulemaking on the back burner, waiting for EPA to follow its process, to complete its SBARFA panel, and to publish its proposed rule. And we expect really anytime now, between now and the next month or two, we expect OSHA to initiate its SBARFA process, wherein it will also make specific proposals for how it intends to amend its PSM standard, and invite small business representatives to convene with OSHA to talk about how OSHA's proposed amendments would affect small business. And then likewise for OSHA to follow the rulemaking process, ultimately to complete the SBARFA process and actually submit a proposed rule amendment in the Federal Register for comment by the public at large. Other changes we expect through the Chemical Facility Safety and Security Working Group is a slight change in the Process Safety Management National Emphasis Program inspections that have continued in earnest for really the last more than 8 years. Beyond just the Obama administration, there had been a refinery national emphasis program, then a chemical facilities national emphasis program. The refinery emphasis program ended. All of the refineries in the country were inspected under the program, and we've been waiting for sort of round two or some modified version of the refinery PSM NEP. We've just gotten an announcement from OSHA that they intend to retool the chemical facility NEP, which has continued in earnest throughout the last several years, that OSHA intends now to retool the chemical NEP to pull in refineries. So there won't be a separate refinery NEP2. Instead, there will be a ChemRef, a chemical facility, and refinery NEP that pulls in refineries into the sort of more shorter, more focused, tailored NEP inspections we've seen at chemical facilities, refineries, the round 2 for refineries will just be pulled into that chemical facility NEP program. So talking about rulemaking, because this is really where we've seen the most activity by these two agencies, by OSHA and EPA. We talked about how OSHA put out their RFI shortly after the President's executive order. And the RFI called for feedback from industry about 10 different topics, 10 ways that OSHA was considering amending the PSM standard and asking for feedback from industry about that. And you can see some of the topics here. One that has been a high priority item for OSHA for a long time, since the Mir decision, where OSHA has been trying to find ways to either eliminate or carve out the exception that was created for atmospheric storage tanks, that the volumes of highly hazardous chemicals stored in above ground atmospheric storage tanks would not count towards PSM coverage. OSHA has proposed in this RFI that they are looking at eliminating that exemption or making changes to that exemption, and invited feedback about that. OSHA has been looking for years. Industry groups, organized labor have been calling on OSHA to include in coverage under the PSM standard reactivity hazards, reactive chemicals. So OSHA has invited feedback about that, or did invite feedback about that. The period of time to comment on the RFI has closed. OSHA is also entertaining adding or updating chemicals to the Appendix A list of covered highly hazardous chemicals. Perhaps adding more management system elements, and we'll talk about what some of those are specifically. Adding a definition for recognized and generally accepted good engineering practices. This is one of the most highly cited elements of the OSHA PSM standard, and yet it is undefined in the standard. So OSHA has proposed to define what Reg-A-Gap means, what Reg-A-Gap is, and how OSHA will enforce it. And then also an element here, and this is a big deal, that we expect to be part of, if not EPA's RMP proposal, then certainly OSHA's PSM proposal, a requirement to evaluate updates to Reg-A-Gap. Reg-A-Gap is basically your recognized industry standards, consensus standards, code-setting standards that are not part of the Federal Register, not part of the actual regulatory landscape. Those guidance documents are more or less enforceable by OSHA, or at least OSHA takes the position that they are enforceable mandatory standards. And these consensus documents update regularly and frequently, some as often as annually. And OSHA is suggesting now, or at least calling for feedback in its RFI, to incorporating into the PSM standard a requirement for operators, for chemical manufacturers, for refiners, to evaluate the regular and frequent updates that are made to Reg-A-Gap and update their own internal policies and procedures, maintenance integrity, mechanical integrity procedures, to update as Reg-A-Gap updates, which would be an incredibly burdensome process. So that's one of the big issues that we're tracking in that regard. Others that we think are really important and that we're going to talk about today include possible changes to the 3-year compliance audit requirement, both in the context of how many units need to be included in those compliance audits and who should be conducting those compliance audits. We'll talk about that in some more detail as we evaluate EPA's proposed rule amendments. And then also OSHA talked about some new changes in the way that employers will be required to coordinate with local emergency responders. EPA followed up OSHA's request for information with its own request for information, and EPA incorporated the 10 items we just talked about from OSHA's list and added some of its own. And we've highlighted here the ones that have made their way from the request for information into the proposed rule that was just published in the Federal Register on Monday. And those are perhaps requiring an analysis of inherently safer technology, inherently safer chemicals, inherently safer procedures, alternatives to the procedures, chemicals, and technologies that exist at our workplaces today. So this would be a very broad and burdensome new requirement. We'll talk about specifically what EPA has in mind in that regard. Emergency drills, something that have not been mandatory under the old regulatory scheme, something that OSHA and EPA called for feedback about in the RFI, and in fact which have been incorporated into EPA's proposed rule in the Federal Register. Other important changes that EPA forecasted in their RFI and which have made their way into the Federal Register include changes to incident investigation requirements and accident histories, which need to be maintained and reported in your RMP submissions. And then also some public disclosure of information, sharing information with local emergency response organizations and with the community at large surrounding your workplaces, new requirements that will be built into the rule, that we expect to be built into the rule based on this forecast in the RFI. So EPA, following the closing of the window to respond to the RFI, initiated a SBARFA process. They call it the SBAR process, but it's really the same thing, the same as OSHA's SBARFA process, where small business representatives get an advance copy of either the proposed rule, proposed language, or a detailed outline of what the agency intends to do in the proposed rule, and they convene where the small business representatives get an opportunity to offer feedback about how the proposed rule would impact small business. And that process began back in September of 2015 and continued through this month when the process closed and a report was issued about small business feedback to the proposed rule. What we saw in this process was that EPA whittled down its list of 19 issues that it identified in its RFI to 6 issues that it looked like would be included in a proposed rule. And what we heard from folks at EPA is that it's not that EPA lost interest in the other 13 items in the RFI. It's not that EPA doesn't think those are important issues to see in a change to the RMP rule. Our understanding is that the list was whittled down to 6 because EPA believed that that was a feasible set of changes that they could get done during the Obama administration. So looking at the clock, looking at the window closing on the Obama administration, EPA said, what can we get done by the end of 2016 or the very, very beginning of 2017 so we can affect President Obama's executive order while there is still a Democrat in the White House. And so they picked either the 6 most important issues, or I understand the 6 issues that they thought they could get done either with the least amount of controversy or that they could, demonstrate presented the least amount of burden so that they could get this through the rulemaking process and survive a legal challenge. I question some of those conclusions because some of the items that are included were included in the SBARFA process and were included in the proposed rule just released in the Federal Register are extraordinarily burdensome, at least as written. So hopefully hearing from the rest of industry, the concerns that industry has and the better ideas that industry has about this rule, we can affect some change to what's been proposed. But these are the 6 items: third-party audits, third-party compliance audits, and when and how to conduct and how broad to cover third-party compliance audits. Incident root cause analysis. So incident investigation have been a part of PSM and RMP since the beginning, but there are proposed changes to what would trigger or what should trigger an incident investigation and what needs to be included, really the scope of incident investigations that are to be done under the rule. And you can see root cause had never been part of the proposed rule, had been part of the existing rule, is now part of the proposed rule. So it is a specific type of incident investigation that needs to be done now. Probably, perhaps the biggest and most consequential proposed change is a requirement for operators, employers to consider inherently safer technologies, inherently safer chemicals as part of a PHA or as part of its own independent, safer alternatives analysis. This is a big deal, something that the Chemical Safety Board has been pushing through some of its investigations, something that labor organizations have been pushing in their discussions with OSHA and EPA. And here it is in this proposed rule. We'll talk about exactly what this means, what EPA is expecting employers to do, and what the legal requirements will be if this becomes the law. We also saw proposed changes in this in the proposed rule to how employers must coordinate with local emergency response organizations, and then also to coordinate with the public through public information sharing. And all of this is rolled up in these 3 items at the end: mandatory emergency response exercises, coordination with emergency responders, and public sharing of information. So let's talk about each of these 6 items, one by one, what they mean, what's going to be required, what the proposals include. The first, the third-party compliance audit. This is a big deal because right now, the defining characteristic of the PSM standard and the RMP rule is that they are performance standards, that employers, that operators get to decide within reason how to implement the purpose and the goals of the standard. There is not a prescribed way that audits must be conducted. There is not a prescribed person who must conduct audits or criteria that person must meet to be able to perform the legally required compliance audit. That stands to change if this proposed rule becomes the law. And the proposal is to require that a third party, not just any third party, but a competent and independent third party, must conduct a compliance audit, a PSM or RMP compliance audit for the operator within the sooner of 12 months from any RMP reportable incident or 3 years from the most recent compliance audit. That it must be a third party that conducts the audit within 1 year if you have a reportable incident, or 3 years of the last compliance audit. And the third party scope, the scope of the compliance audit, in theory, does not change, except there is a controversial dispute with EPA right now about what is the required scope of compliance audits, RMP compliance audits. And we'll talk about this in more detail, but to give you a tiny bit of background, it has been widely accepted, universally accepted by OSHA, and what we understood to be universally accepted by EPA, that if you have a chemical manufacturing facility or a refinery where you have dozens, perhaps as many as 30 or 40 operating units, that you may select a representative sampling of units to cover in your compliance audit. This is not the PHA that is granular, that gets down to the specific hazards of each operating process. This is the compliance audit evaluating how your PSM and RMP programs are being implemented at your facility. It's always been understood that you could do representative unit samples to evaluate how the programs are being implemented. EPA has sort of out of the blue, just over the last 2 or 3 years, taken a new view of that. And instead of taking the position that representative sampling is not acceptable, that instead operators must do a compliance audit of all PSM and RMP elements in all units at least every 3 years. So the idea here that the scope is not changing for compliance audits is not really accurate. EPA is trying to change the scope of audits, but the purpose of this third-party element is to just talk about who conducts the audits, not how the audits are conducted. But those are 2 separate issues that are being addressed both through enforcement and through the rulemaking that EPA has just announced. But right now, we're focused on what this third-party auditor issue means. And there are 2 sets of criteria that EPA has introduced for what this third-party auditor must look like. And one is competence. And the competence criteria are that the third-party auditor must have knowledge of the risk management program rule, must have knowledge of the facility type that they are auditing, must have knowledge of the processes being audited and the applicable reg gap that applies to those processes. The third-party auditor must be trained or certified in proper auditing techniques, and there are some certifications out there for certified, process safety auditors, but there are very, very few people in the country that have that certification. So this would be a pretty significant burden to add to this requirement. And then finally, and a very significant burden, is EPA is suggesting that the audit team must include at least one licensed professional engineer. And that is certainly not a requirement today, and generally not something that we're seeing in industry. So 3 new requirements here: that the auditor be competent or demonstrate competence by having knowledge of RMP, the facility type, a refinery, chemical manufacturer, specific chemical manufacturer, and the processes being audited, that they have a certification or demonstrated training in auditing techniques, and that there be a licensed professional engineer on the audit team. In addition to the competence requirements, which are slightly less controversial, there is also new criteria introduced for independence. This third-party auditor must be an independent auditor. And this is where industry is really struggling to see how they can continue to conduct audits under this rule and how this is a feasible requirement. Because what OSHA and what EPA has announced this already. OSHA is following suit, and we understand that their proposed rule that the SBARFA panel will see soon will include similar parameters. That this requirement for independence, an independent auditor is an auditor who receives no financial benefit from the outcome of the audit apart from payment for the audit service. That's not all that controversial. In other words, the guy is not paid if he keeps recommendations under 10 recommendations. Not so controversial. But where it gets controversial is that an auditor would not be deemed independent if that auditor has performed any design, construction, or other consulting services for the company being audited within the past 3 years. So if you have been involved in other audits, if you have been involved in PHAs, if you have been involved in any other design work or implementing recommendations from past PHAs or PSM audits, you would not be considered an independent auditor and would not be eligible to do the next compliance audit for that company. Likewise, the independent auditor would lose his independent status, would not be considered an independent auditor if that auditor performs any design, construction, or consulting services for the employer over the next 3 years. You cannot provide any other services, including additional audits, including implementing audit recommendations from the audit for the next 3 years going forward after the audit, and likewise cannot accept employment with the employer for the next 3 years. And these auditors must certify their independence in the audit report and certify that the audit report contains no false statements. This is extremely controversial and, frankly, creates an infeasible situation because auditors, consultants, experts in the industry make a whole lot more money from all of the other consulting services that are precluded by this independence criteria than they do from doing compliance audits. So the pool of compliance auditors will shrink or disappear or replace really good competent auditors with less competent auditors who are not in line to be hired to do any of the other design and construction services anyway. So you are, we think, either making an impossible situation where you will not be able to find auditors at all that meet these criteria, or at the very least, you will be eliminating really good, effective, competent auditors and replacing them with less competent, less effective auditors. So a dangerous new change being proposed here. Let's see. The next item that was reviewed heavily in the SBARFA process and that has been included in the proposed rule just released on Monday is the changes to the incident investigation requirements of the RMP rule. It had always been a requirement that if you've had an RMP incident, which was a catastrophic release or an incident that could have resulted in a catastrophic release of highly hazardous chemicals, you must conduct an incident investigation. The proposal that's out there now and that was reviewed with small businesses would redefine what is a catastrophic release, and more importantly, redefine or add and define the term near miss. And that's where the big issues kick in, because we're already doing RMP incident investigations for things that we recognize to be catastrophic incidents or an incident that could have resulted in catastrophic consequences defined by the RMP rule, but that there is a change proposed now by EPA that included in this catastrophic incident that triggers an incident investigation are any process upset that involve activation of relief valves, interlocks, or release alarms. And there's other issues here as well, but those are the ones that have jumped out to me and to others in industry as not really being a good indication, not really being a good trigger for the type of event that is a catastrophic incident or one that would likely result in the catastrophic criteria. That every time a relief valve lifts, every time an interlock is triggered, and every time a release alarms, every time a release alarm alarms are not really indications. Some may be, but many are not indications that you've had a near miss of a catastrophic type of incident. But these would now be covered by, if this proposed rule becomes the law, these would become incidents that require employers to do an incident investigation. On top of that, OSHA or EPA has proposed to change the nature of the incident investigation that is required. And historically, again, this was a performance standard. Employers had discretion for what that incident investigation would look like, what it would cover, how extensive it would be, the nature of the investigation itself. And EPA is proposing to really convert this from a performance standard, at least in regards to incident investigations, and make it more of a specification standard by defining specifically what operators, when they must conduct these investigations, what must be included, what the reports must look like, what should be included in the reports, and identifying certain facts, certain conclusions that must be investigated and reported in your root cause in your incident investigations. And I sort of slipped there to root cause because that, to me, is the biggest change here, that EPA is requiring that the nature of your incident investigation be a root cause investigation. And as defined by EPA so far, there is a call for a root cause investigation that looks at the fundamental underlying system-related reasons why incidents occurred and the correctable failures in management systems. And again, this is sort of, saying not only are you doing a root cause investigation, but our view of the root cause is that the root cause will always be some management system or system-related failure. It can't be that it was employee misconduct. It can't be that it was some human factor. There is always going to be some management system failure that caused this incident or near miss to take place, and that is what the root cause investigation must look for and identify in the incident investigation report. So another, I think, pretty consequential proposal that EPA has made to their rule. So inherently safer alternatives analysis. This has been one that has gotten, I think, the most ire of industry, the most feedback I've received from my clients and others in industry that I've heard talk about the proposals from EPA and what we expect from OSHA are that EPA intends to build into the RMP rule a requirement for operators to analyze and assess the existence of and the feasibility of inherently safer technologies, IST. And it's not just technologies in the context of engineering controls. This also includes the chemicals that you're using, the processes that you're using, the administrative controls and engineering controls, inherently safer technologies. And what this means in EPA's definition is that these are measures that will reduce or eliminate hazards by minimizing, substituting less hazardous chemicals, moderation in the process of hazardous chemicals, or simplifying a process and procedures. And the RFI comments urged EPA to incorporate, comments from labor groups and others, encouraged EPA to incorporate inherently safer technology analysis into the RMP rule. And based on the SBARFA process and what we're seeing now in the proposed rule in the Federal Register, is that EPA is doing that. They are trying to incorporate a requirement for inherently safer technology analysis into the RMP rule. CCPS guidelines promote the use of safer technologies to improve chemical safety and to reduce the risk of accidents. And EPA is trying to model their proposed rule on some CCPS guidance and acting on recommendations from CSB, from some of their investigations and EPA's own inspections, concluding that incorporating inherently safer technologies could have prevented serious incidents and accidents. So what is this going to look like? The proposal is that refiners, chemical manufacturers, and pulp and paper producers include in their process hazard analysis an analysis of potentially safer alternative technologies and chemicals. So the idea would be that your PHA now would identify existing or things that could exist, that you could develop, that you could engineer, alternative safer technologies and or chemicals, and that you will consider in a specific order of preference in a hierarchy of controls inherently safer technologies or designs, passive measures, active measures, procedural measures, substitution of alternative chemicals, or the moderation of the use of the volume of chemicals that you use in your process and procedure, so that your PHA will evaluate the existence of these and identify those that may be the most feasible in this hierarchy of controls. And more specifically, the idea would be that the PHA includes a description of how your IST analysis was done and findings and recommendations from your IST analysis. There is supposedly not going to be any prescribed level of risk reduction. So it's not a matter of saying, if you have a risk matrix and you say you could take things from a risk level 4 to a risk level 2 by substituting in this alternative chemical, there is not a mandatory, you are not required to implement that just because it will reduce it by 2 levels on your risk matrix. There's not going to be a requirement like that. There's just a requirement that you do the analysis, that you describe how the analysis was done, and that you document the findings and recommendations of the analysis. The IST analysis can be done using existing PHA methodologies or other recognized methods for analyzing inherently safer technologies. Before implementing inherently safer technologies, operators may consider the feasibility of implementing that IST, and EPA recognizes and defines feasibility in this context to mean the ability to successfully implement it within a reasonable time, the economic feasibility, an important recognition there by EPA that you only must implement economically feasible IST. The process can continue to be operated. Unfortunately, the way the government defines feasibility is that you won't go out of business by implementing it, and that's, EPA seems to be following that same model, that you can continue to operate the process without financial ruin is what economic feasibility means. Environmental feasibility, social feasibility, and technological factors all can be considered by employers when they analyze, okay, we've identified that these inherently safer technologies exist, but we are not going to implement them because they lack, they're not feasible to implement in this process. So this is a very big deal. This is going to be an item that I'm sure will be commented on extensively by employers in the EPA rulemaking and the OSHA rulemaking that will follow, and perhaps very likely to be the subject to a legal challenge if EPA does not heed the comments of industry. So the remaining 3 items in the EPA proposed rule are about coordination for emergency response, emergency response drills, and public information sharing. I'm not going to go into super detail on this, but the idea is that EPA is proposing to clarify and expand the existing duty to coordinate with local emergency response organizations. That exists right now in RMP. It does not in PSM, but the idea here is to expand on the duties that are outlined in a minimal way in the current RMP program. And it would get specific, again, eliminating some of the performance elements of the rule and going to specific timing. You must coordinate annually with LEPC, local emergency responders, ensure that the response capabilities exist either with the outside responders or internally, ensure that and document that. You're documenting your coordination efforts. Who will be responsible for responding to certain types of incidents? How have you coordinated? What types of drills have you done? What types of information have you shared? And making sure you're doing that in a formal and documented way. Emergency response exercises will become mandatory and will become defined as to when and how you conduct these exercises. There will be a requirement to, and the requirements differ depending on whether you are a non-responding facility, whether you have an internal emergency response organization or rely entirely on the local emergency response organizations. But generally speaking, there will be requirements for both field exercises and tabletop exercises, field exercises every 5 years, and tabletop exercises annually during the 4 years between your field exercises. And there's some definition around what should be included in these field and tabletop exercises. And there will be requirements built into the rule about how you document these exercises and how you, also a requirement that in the process of doing them, that you evaluate the effectiveness of the response and, like you do from PSM compliance audits and PHAs, putting out recommendations and developing action items and documenting all this, how you're going to putting together a schedule for how you're going to respond to the recommendations, and then implementing the recommendations. The information sharing elements of the proposed rule are twofold. There will be new requirements for information that must be shared with the emergency responders, local emergency response organizations, and information that must be shared with the public. I'm not going to go through all this in detail, but there will be requirements that you document and share with emergency response organizations, information about the hazardous chemicals or the chemical hazards present at your facility, summaries of the incident investigations that you've performed, based on this new threshold for RMP investigations that will be required, summary of your inherently safer technology analysis, things that you're implementing, the analysis, the conclusions that you've reached from your analysis, and what you're implementing and by when you'll be implementing it, and then summarizing your emergency response drills, sharing with local emergency response organizations the findings, recommendations, and action items from your emergency response drills. With the public, it's the same categories generally of information you're sharing, but it's slightly less information or information in less detail that you're sharing with the public. But you are going to be required under this new rule, if it's implemented, to share chemical hazard information, lists of the regulated substances you have on site, quantities and copies of SDSs, and your 5-year accident history. From your emergency response program, you need to share with the public whether you will be handling, whether the operator or the employer will be handling emergency response internally or relying on outside emergency response organizations. Identify the contact information of local emergency response organization or the emergency response responsible entity, and then the procedures, your procedures for how you will inform public and local emergency responders of accident releases. That all needs to be shared with the public under this proposed rule. Also need to share information with the public about local emergency response organizations, and then a summary of your emergency response drills, sharing with the public when the drills were done, what you learned from the drills, how you conducted them, and what recommendations and action items came out of those drills. For public, for the logistics for how operators and employers are going to be required to share this information with the public. The expectation is that employers will hold regular public meetings to share hazard information. That means at least every 5 years, or in the proposed rule, within 30 days of a RMP reportable incident. And every time there is an RMP reportable incident within 30 days, there's an expectation that you will hold a public meeting and share information about that incident. The topics for the public meetings include the hazards of the chemicals you have at your establishment, how you plan to address those risks and prevent accidents, descriptions of actions taken to prevent reoccurrences of incidents, and letting the public share its concerns with you and addressing those concerns. They must be held in public spaces. They must be multiple facilities may hold public meetings together. So you could do a joint meeting with neighbor chemical manufacturers and do this in coordination. The public meetings must be held in concurrence with regularly scheduled LEPC meetings open to the public. They may be held in concurrence with those types of events for your convenience. And then you must notify the public by publishing notice in either the local paper, by social media, and or by flyers in public spaces like the public library, city hall, etc. So where are we in this rulemaking process? Some pretty substantial burden is being introduced here. There is still plenty of opportunity to try and shape this rule and to improve it, or to convince the agency to leave things how they are. We have gone through the SBARFA process with EPA that basically ran from September of last year through March of this year. And now presently a report was issued by the SBARFA panel, and the proposed rule has been published for public comment. It is set with a 60-day comment period. So within the next 2 months, unless there is a extension of time to the comment period, which we anticipate organizations will be asking for, there will be 60 days or more for public comment. Within, I think, about a month from now, there is set to be a public hearing where testimony will be heard from interested parties about the proposed rule. There will be comments submitted to the proposed rule, perhaps a final hearing where more testimony can be heard, and then a rule will be published. EPA is dead set on getting this rule finalized during the Obama administration, which means this will be happening in less than 1 year. I do think that they will get that done. I do expect that that will happen. And then when the rule is pushed through, depending on how much the agency heeds the comments of industry, I would fully expect that there will be legal challenges to this rule, in particular based on the feasibility of some of the proposals here, so, around the third-party, independent third-party requirements introduced by this proposed rule, and likewise the inherently safer technologies requirement. Both of those I expect to be challenged if they are part of the final rule. One of my good friends has just commented here that the public hearing is scheduled for March 29th. So really in less than, in just a couple of weeks, it sounds like we'll have the first opportunity for industry to have its voice heard on this proposal. So that's the rulemaking activity. One other area I want to touch on from an EPA standpoint real quickly before I give it to Amanda to talk about some PSM issues is RMP compliance audits. And you heard me touch on this briefly a moment ago, but there has been a long-standing requirement in both the RMP rule and the PSM standard that that employers, that operators are required to evaluate the status of compliance of the implementation of your RMP program, of your PSM program, every 3 years. An industry practice driven by CCPS guidance, driven by guidance by really every organization that has looked at this and introduced best practices, has said if you have multiple operating units, auditing representative units is an effective way to conduct an RMP PSM compliance audit. And that has been acceptable by OSHA and by EPA for the decades now that these rules have been in place. Recently, however, EPA has started to bring enforcement actions under the RMP rule, RMP inspections, notices of violations for finding that compliance audits have been conducted. They've been conducted every 3 years, and they've been conducted with, addressing all of the elements in an adequate way, but they have not looked at the implementation of all of the elements in every covered process. So in other words, it's a violation to use representative units in these RMP compliance audits. This came out of the blue. There was no interpretation letter. There was obviously no rulemaking, and OSHA was not doing this. I mean, OSHA had just completed the refinery NEP and is doing dozens and dozens and dozens of inspections under the chemical facility NEP, and there was not a single violation for not conducting RMP audits in every unit every 3 years because it's not a requirement. But EPA has introduced this as a new requirement. OSHA and EPA's rules on compliance audits are virtually identical. There are minor word differences where the schemes use different language. We talk about operators instead of employers, things like that. But otherwise, the rules are identical, and there is substantial guidance out there by OSHA and EPA and case law and preambles and everything that says we want these to be enforced the same. We, EPA and OSHA, do not expect employers to do different things or to have to do different things to comply with these two different regulatory schemes. The expectation is if you're complying with PSM, you're complying with RMP, and OSHA has long accepted representative unit sampling for RMP, for PSM audits, and so had EPA. So this was a very surprising change in position by EPA. We think the guidance is out there that is very effective, that OSHA references on its website, that EPA references on its website, that says there are two ways to effectively audit a PSM program and an RMP program at facilities that have many units. One is to audit some elements of your PSM program in all of your covered processes, or to audit all elements of your PSM program in some subset of your covered processes. Either way, you're doing representative sampling for your audit program. EPA has said, sorry, that's not good enough. We're not going to accept that anymore. We think the old representative sampling makes a ton of sense, especially when you think about the dual audit elements of PSM and RMP. The PHA is a very granular, very unit level, very hazard specific level review of each unit. You can't do a representative sampling for PHA. We get that. That makes sense. But for program audits, PSM and RMP audits, you're talking about the elements of your program and how they work. And all of my clients, generally speaking, will implement, your MOC program the same across all of your units. You implement your training program the same across all of your units. You have a similar or substantially similar methodology for P&ID drawings and PFDs and your process safety information. So it is appropriate to do representative unit sampling. But EPA, as we said, has gone away from that and started to issue enforcement action notices of violation on that issue. An industry working group that I've been working closely with has been working with EPA to get to the bottom of this. Where is this change coming from? Why are you doing this? And if you intend to do it, we need to get OSHA on the same page, which really means moving EPA back to where OSHA has been and stop enforcing this in a unique way. Or if you really think this is a necessary or appropriate change, include it in your rulemaking, because this is not the way the rule has been enforced, not the way industry has understood the rule for the last couple of decades. And, EPA has sort of dug their heels in and said, we don't think this is new at all. There was a brief reference to all units in a preamble to a preliminary proposed rule or a notice of proposed rulemaking, which didn't surface again in the preamble to the final rule. It didn't surface again in the final rule, but EPA is suggesting that this is just the way it's always been, even though we'd never issued a notice of violation about it until 2 or 3 years ago. We are, I think, making some progress with them, that they recognize now that there is guidance on their own website that suggests representative sampling is acceptable. And so as a result of that, it does appear that EPA has included in the proposed rule in the Federal Register to change this. It's in the proposed rule, and therefore, to me, that means there's a recognition that that's not the existing rule. If the proposed rule proposes to require RMP audits in all units, all elements, all units every 3 years, that seems to be a recognition that that is not the current rule. So hopefully that will help resolve the existing notices of violation and give EPA an opportunity to hear from industry why that will actually make for worse audits. It will make things less safer, not more safe, if we require that type of audit. And so we're going to be including that. Obviously, industry will have an opportunity to respond to that through the hearings and comments to the proposed rule. But that was an interesting element that we've seen develop on the RMP front. So I've talked pretty steady for a while now. I'm going to turn things over to Amanda to talk a little bit about what's going on from an OSHA PSM context, since I've covered the EPA RMP context.
Good afternoon. Thank you for joining us. This is Amanda. Can everybody hear me okay? I am going to be talking about OSHA's recent interpretation letters that Eric had mentioned several times in the earlier part of the presentation. And a great way to kick off this discussion is talking a little bit about background and why we're seeing so many of these letters coming out in 2015, or why we saw so many of them come out in 2015. And one of the big, in addition to the executive order, the presidential executive order that Eric mentioned earlier, another significant factor in the 2015 PSM interpretation letters had to do with a ruling issued by the Supreme Court. It was called Perez versus Mortgage Bankers Association, and it was basically a decision. It did deal with the Department of Labor regulation. It was not an OSHA regulation, but it basically dealt with the classification of mortgage loan officers and whether or not, for purposes of the Fair Labor Standard, and whether or not they were eligible for overtime pay. There had been an interpretation letter issued in 2006 that said that they were not, and then a letter issued also by the agency in 2010 that reversed the earlier interpretation letter, and of course that was challenged in court. And at the D.C. Circuit level, the mortgage bankers case, D.C. Circuit sided with an earlier ruling that they had from 1997, a decision from Paralyzed Veterans of America, saying that they must follow notice and comment procedures to issue new regulatory interpretations that deviate from prior interpretations. This was challenged to the Supreme Court level, and the Supreme Court level set aside this rationale by the D.C. Circuit. They stated that the text of the Administrative Procedure Act did not mandate notice and comment rulemaking for interpretive rules. So basically this took a pretty significant constraint off the agencies when they want to issue interpretive rules, instead of going through the long rulemaking process, which can be very time-consuming, notice and comment, hearings, notice of proposed rules, much more comprehensive than just issuing a letter as they did with regards to the PSM issues that I'm going to be talking about here in a moment. And as the last point here on the slide indicates, agencies will now seek to avoid notice and comment rulemaking by claiming a new interpretation of their own regulations are only interpretive, and that's certainly what we're seeing in this context. Moving on to the OSHA interpretation letters that were issued in 2015, there were 3 of them. They came out in the beginning of June in 2015. And of course, they were all considered or identified as interpretive rules. And the first one dealt with rugged gap in the PSM enforcement context. We'll talk more in detail about each one of these as we go through the following slides. But some of the major points from that one included the interpretation of shall and should language in compliance documents and consensus documents, as well as the use of internal standards for rugged gap. And the second one had to do with covered concentrations to determine PSM applicability and the percentages of each chemical that would trigger that PSM standard. And then the third one, narrowing the retail exemption that had been in effect since the early 90s when the PSM regulation came out. Turning to each one of the interpretations in more detail. The first one, the REGA-GAAP interpretation. REGA-GAAP is closely intertwined with the PSM standard and stands for Recognized and Generally Acceptable Good Engineering Practices. This term actually appears 2 times in the PSM standard. First in the Process Safety Information section, where employers are required to document that process equipment complies with REGA-GAAP, and then again in the Mechanical Integrity section, indicating that testing and inspection procedures of process equipment must comply with REGA-GAAP. Even though it does appear twice in the standard and employers are required to comply with REGA-GAAP, there was no specific definition offered by the final rule or any guidance, a specific definition of what OSHA interpreted REGA-GAAP to stand for. Some of the most interpretive language we have comes from the preamble of the final rule, and REGA-GAAP was intended to include appropriate internal standards of the facility, as well as codes and standards published by NFPA, ASTM, and ANSI. And OSHA took the opportunity in 2015 to put some more meat on the bones of what they interpret REGA-GAAP to mean. And they basically laid out 4 acceptable categories of REGA-GAAP. The first one being the basis for engineering operation or maintenance activities or themselves based on established code standards, published technical reports, or recommended practices. And this basically amounts to external standards that individual employers could develop on their own and apply for mechanical integrity and process safety information purposes. The second one was published and widely adopted codes. This is along the lines of the NEC electrical code, and other documents like NFPA. Published consensus documents such as ASME, ANSI, those sorts of documents would also be an acceptable form of REGA-GAAP. And then also published non-consensus documents such as materials from CCPS, as well as pamphlets that might be put out by other organizations such as the Institute, the Refrigeration Institute. The most significant one of these points, I think that caught everybody a little off guard, was with regards to the first one and the internal standards. As OSHA had indicated in its preamble, employees' internal standards were an acceptable form of REGA-GAAP. And in the new interpretation letter, OSHA certainly seems to be backpedaling on that. Basically, employers are still able to have their own internal standards, but they have to be at least as protective as the other forms of recognized REGA-GAAP. So basically they have to be more protective, and they must now document how they alternate from the other 3 forms. And this essentially translates into REGA-GAAP being limited to published codes and standards from the employer perspective. I think ready to go on to the next slide. Some of the most significant impacts that this new interpretation will have is OSHA's application of the shall versus should in consensus standards. OSHA's taken an approach previously that shall usually means for enforcement purposes that the employer must comply with that requirement in the consensus standard or in the REGA-GAAP. And now they're taking that and applying it a little bit more broadly and applying it to the should language. Now OSHA is carrying that over to the same enforcement approach, essentially to the should language. And basically an employer will be presumed to have a violation if they deviate from the shall or shall not language adopted in REGA-GAAP. That violation presumed when an employer implements practices when REGA-GAAP says they should not be implemented, and kind of a catch-22, a violation will be presumed when an employer meets industry consensus REGA-GAAP, but not their more stringent internal requirements. Which would essentially mean that if there's a testing or inspection requirement, it's every 2 months, and the employer has their own internal standard that requires it every year, they would be in violation, or OSHA would presumed that there would be a violation if they had not inspected the piece of equipment for 18 months. This has been found to be very troubling within the industry, and basically finding a significant reliance on the published REGA gap that is out there, making them basically the new legal standard by which OSHA will do its evaluations to determine whether employers are in compliance with REGA gap. One of the more particularly troubling aspects of this interpretation has to do with the updating of REGA gap. It's a pretty common occurrence for the REGA gap to be updated by committee, and OSHA is saying when there's an explicit retroactivity clause mentioned in the updated REGA gap that employers would be expected to comply with it and confirm updates in the selected REGA gap. And when there is not an explicit retroactivity provision, employers are still going to have to assess the change and document whether the change is required and include why or why not. So that's a pretty tremendous burden that a lot of employers are concerned about, and something that's being taken into consideration. The second PSM interpretation letter that was issued relates to OSHA's new chemical mixture coverage interpretation, and this deals with the 126 chemicals in Appendix A that did not have a specific concentration listed to trigger PSM coverage. The rest of them do have a specific percentage covered, and those are kind of a separate category. This applied to the 126 that did not. The old policy used max commercial grade for pure chemical grade as a trigger when concentration was not listed, and typically that would mean the typical maximum concentration of the chemical that is commercially available and shipped. OSHA would allow employers to reference sales catalogs and so forth to look at the percentage, concentration percentage for purposes of applicability. OSHA is now getting rid of this interpretation and making it a flat 1%. They acknowledge that there was some confusion with their old interpretation, and they are arguing that this new clear interpretation would be much clearer for employers. But in addition to that, it also has some additional issues. It would certainly cover a lot more chemicals, or a lot more individual processes could be brought under the jurisdiction of the PSM standard. To determine if a process has a applicable chemical in a mixture above the chemical threshold quantity, total weight of the covered chemical in the mixture at a concentration at or above the concentration trigger listed for the chemical in Appendix A, or if Appendix A does not list a concentration trigger, then you would be at the new 1% rule. If that listed chemical has 1% in the total mixture, then it would be part of a PSM covered process. And as the next note indicates, the count of the weight covered by the chemical in the mixture is not the total weight of the mixture, it's the actual covered chemical that's listed on Appendix A for PSM coverage. And then there's also one minor exception or exemption that do not necessarily need to include the weight of chemicals and portions of processes in which partial pressure of chemical in the vapor space under handling or storage conditions is less than 10 milliliters of mercury. And this is an exception that should be documented, and the determination should be documented in case there's any issue with regards to OSHA. Also, too, with regards to this mixture rule, there's been a considerable discussion with regards to hydrochloric and hydrofluoric acid. There's actually been a long-standing confusion with these particular chemicals. In Appendix A, when it was published, it came out and indicated that hydrogen chloride gas, and then in parentheses, anhydrous, was actually covered by the standard. Then subsequent interpretation letters have supported the fact that that is a separate chemical. Then hydrochloric acid, OSHA actually issued a publication or an interpretation letter in 1994. However, they seem to be backtracking from that a little bit and seem to want to include hydrochloric acid as a covered chemical, which would certainly cover quite a few more processes if we have that interpretation in addition to the 1% rule. And if it's covered, there certainly will be a lot of new employers that are covered. Asphalt is one of them that recently comes up in quite a few discussions, as well as other chemical processes. The third interpretation letter that came out in 2015 had to do with the retail exemption that had been in existence since the early 90s. PSM standard did not define the retail exemption, but interpretations after the fact had stated that if a facility does 50% or more of its income from direct sales of highly hazardous chemicals to end users, then it would not be covered by the PSM standard. Once again, OSHA is backtracking on their previous interpretation and narrowing down that exemption. Basically, the exemption would apply only now to manufacturers, would actually apply only to gas stations and certain facilities that sell some propane tanks to end users, and now PSM would cover manufacturers of feedstock, which is also to another company, farm supply companies storing anhydrous ammonia, and petroleum bulk stations and terminals. So once again, this would be broadening the application of the PSM standard. This is something that would have a pretty tremendous impact on agriculture-related companies, and we've seen a pretty strong lobby against this interpretation that has resulted in, as well, talking about the challenges to these individual interpretations. All of them have been legally challenged. The American Chemical, I'm forgetting the third, Council and AFPM have filed suit in the D.C. Circuit challenging the Rega Gap and the covered concentration interpretations. There's been several extensions on the briefing schedule, and it's currently scheduled to begin on June 10th. However, one of the reasons for the extension are significant settlement discussions. It certainly looks like the Rega Gap interpretation letter and the subsequent challenge are headed for settlement. It looks pretty likely that that's going to happen, and seeing more hope with regards to the concentration interpretation. It looks like settlement discussions are also proving productive in that context as well. The American Retailers Association and the Fertilizer Institute filed suit with regards to the retail exemption. That briefing process has been completed, and we're now waiting for a decision. In the meantime, in addition to the legal challenge, the lobbies supporting the American Retailers Association also did get a rider to the federal budget preventing OSHA from enforcing the new retail exemption. There has also been a stay put on enforcement relating the 1% rule and the Rega Gap interpretation until the result of the legal challenges. So that is kind of an update, a quick update with regards to where the three PSM-related interpretation letters stand.
Yeah, and just in the context of PSM rulemaking, I think this was in the slides, but OSHA sort of sat back and let EPA take the lead here, because EPA is much more efficient at rulemaking. They could actually get something done during this administration. So now that the SBARFA panel is closed for the RMP rule, the PSM SBARFA is set to begin. They thought it would actually be ready to go already. I expect to see it in the next month or 2 months, that there will be a proposed regulatory language or an outline of the proposed regulatory changes presented to small business representatives. That process will run a few months, and OSHA will close that and then introduce, I do expect that they will introduce a proposed rule in the Federal Register before the end of the Obama administration, but I think there is about a 0% chance that the PSM amendment will become a final rule during this administration. But the EPA rule, the RMP rule, I do expect that to proceed to a final rule during this administration. So that was our PSM RMP update. I would encourage you all to check out our blog, the OSHA Defense Report, www.oshadefensereport.com. We've been writing on PSM, RMP issues, OSHA's reporting rule, all kinds of other good stuff on there. So definitely check it out. There's an opportunity in the top right corner to sign up and get and just get an email every time we put a new article up on there. I'd encourage you to do that. And then I definitely would encourage you and invite you to join us for the rest of the webinars in our 2016 OSHA webinar series. If you're not already signed up, you can find on our website. I'll include it in an email that follows this email, a way for you to register for the balance of those events. We welcome everyone's participation. I'm going to address some questions now, and we do have a few that are typed in here. Let's see, we can go back and see what we've got. There's one about do we expect VPP sites to be included in the ChemRef NEP process? And what I heard directly from the PSM team at OSHA that VPP would continue to be excluded, VPP sites would continue to be excluded from the programmed inspections under the ChemRef NEP process. So that cuts down the number of refineries that are subject to the, of course, that limitation is only to the programmed inspections. If there is an incident, an employee complaint, a referral, some other reason for OSHA to show up at your refinery, they will be expanding the inspection to the NEP inspection process. The NEP process, though, is different. If you're talking about the context of refineries, the refinery NEP was an extremely deep dive type of inspection. The chemical facility NEP have been much narrower. They're hand selecting specific elements of the standard to review, hand selecting 1 or 2 units to look in. They are much smaller number of man hours per inspection that we're seeing in those, and that's what the new round of refinery inspections will look like. But VPP will continue to be excluded from that process. There was a question here about whether flour mills and grain elevators would now be covered under the process safety management standard because of the way that OSHA slipped into the GHS hazard communication standard. The hazards otherwise not classified, or whatever the language was, the combustible dust was specifically identified as a hazard otherwise not classified in GHS. The answer to that is no, that flour mills and grain elevators are not now covered by the PSM standard, but that's not to say you don't have other issues with combustible dust. There's obviously the 1910-272 has its own housekeeping provisions, its own combustible dust provisions. We've also seen plenty of general duty clause violations related to combustible dust issues at grain elevators and things like that. But the process safety management standard does not now apply to grain elevators. We've talked about, Amanda talked about the retail exemption changing shape, except for Congress stifling the agency's effort to change that. But there is going to be some change in PSM applicability to feedstock and fertilizer storage and production. But your flour mills, your grain elevators, still going to be primarily subject to 1910-272 electrical safety standards and things like that, but not process safety management. Let's see. We will definitely be making a copy of these slides available to folks and a link to the recording as well. When was the stay issued for the Reg-A-Gap and chemical concentration guidance? That is a very good question, Amanda. I don't know if you've looked into that. I'm not sure that there is technically a stay to those. That was
Actually, there was a stay that was requested in February. I did know from the American Chemical Council, and at the conference we were at last week, I'm pretty sure that Jeff Wanko did say that there was a stay with regards to that, as well as the retail exemption.
But what about the chemical concentration item?
I thought that covered both the Reg-A-Gap and the chemical concentration.
Okay, so that at some point over this winter, that there was a stay put in place into implementing that guidance, it sounds like. So I'd look into that a little bit more. If you have additional questions about that, I'm happy to dig into that and talk about that a little bit more. I think that's all I'm seeing now. Are there any other questions? Let me know. And of course, if you have any other questions after today, please don't hesitate to reach out to Amanda or me. We are always happy to not just questions, but if you have comments, some experience you have to share about this, some involvement you have in some of these activities. We are involved in sort of everything that we talked about today, from the challenge to EPA's RMP compliance audit interpretation, to the legal challenges, to the PSM interpretation letters, and to getting involved in commenting on the RMP rule and the PSM SBARFA process. So we will, over the course of time, continue to dig deep into these things and be able to share what we've learned about that, and we're always happy to do that. I do see one new question here. If the independence requirement element of the third-party compliance audit requirement is put into place, such as you cannot work with a company for 3 years after the audit, is there a grandfathering consideration? That's a great question, something we'll definitely want to raise during the rulemaking process. It's not built in right now to the proposed rule, so the idea being if you have provided consulting services within the last 3 years, you're not eligible to do the next RMP compliance audit. There is not a grandfathering provision that I've seen talked about in any of the either in the SBARFA process or in the proposed rule. So I don't, right now I don't think that would be the case. And the concept here is that, EPA is saying you can't be truly independent, and we can't trust the findings of your audit if you've been paid by the company to provide other services, or are set to be paid by the company to provide future services. So if that is the spirit of the rule, it strikes me that it's not one that they would, without extreme pressure by industry, build in a grandfather provision into. I know that the agency has taken to heart the feedback of industry about this rule, this particular independence requirement, that it's going to essentially eliminate the pool of auditors. So we are optimistic that there will be changes to that particular requirement. But this wouldn't be the first time that really reasonable and smart, meaningful comments from industry are ignored by the agency in the rulemaking process. But I've heard from OSHA and EPA representatives that this is one where there's good data out there that industry has been demonstrating to them. Here's what will happen to the pool of auditors, that they are taking that seriously. So hopefully that's one that we don't have to know whether there's a grandfathering provision, because it goes away altogether, but we'll see. How will auditor knowledge and competence be determined and demonstrated, and who will make that determination? That's another really good question. There is right now built into the proposal a requirement for the auditor to certify in writing in the audit report their own independence, and that they meet the criteria for an independent and competent auditor. So in the first instance, it will be the auditor who certifies that they meet these requirements. But ultimately, this is an enforcement regulation. If EPA reaches some conclusion different than the auditor and different than the operator, and concludes that the person is not truly independent or not truly competent, or doesn't meet the competence requirements, then they can issue a notice of violation, and you would have to defend that they are independent, they are competent. So it seems like it's sort of the onus is put on the auditor in the first instance to certify it, and I would do more than just a statement certifying it. I would maybe document how you meet the criteria, but ultimately it's up to the agency. Well, it's not up to the agency. The agency will make its own determination of whether you should be cited for that issue, whether you've complied with that requirement, and then it would be up to, in the context of EPA, a litigation challenge out to the district court. If OSHA goes along with this, and right now we fully expect this issue to be part of OSHA's proposal, and we've heard them talk about that, then it would be a challenge before the OSHA Review Commission. So that's how we see that playing out. And that is the last question I see in there today. So if anything else, you guys have any other questions, please don't hesitate to reach out to us. Thank you again for joining us. This was, as always, a lot of fun to prepare for, a lot going on, a lot for us to learn about, and we're glad to do that and to visit with you all about it. We look forward to doing it next month on in the next webinar. So thanks again.